Hello students, today I am going to dictate very important legal matter. The topic of the matter is crushing season. 3, 2, 1, start. Learned counsel for the petitioner has been enabled to point out any provision that may define the service conditions of seasonal employee in the said act. The argument advanced by Sri A.K. Yadav that the field in this regard stood occupied with the definition of the phrase crushing season is misplaced inasmuch as the said phrase was simply borrowed from the 1953 Act in the 1975 regulations. The 1975 regulations can be amended in the exercise of the powers so conferred. The regulations having been framed under the UP Cooperative Societies Act 1965 can be modulated under Section 122 of the 1975 Act. The powers for such modulation under the said provisions was conferred on the Cane Commissioner. The impugned notification therefore redefines the words crushing season by limiting its operation between the period commencing from the date of crushing of sugar cane by the concerned sugar factory till the crushing ends. Thus, this amendment has been carried out in accordance with law and in accordance with the provisions aforesaid. They do not militate against any provisions of the 1953 Act which was framed for an altogether different purpose. The 1975 regulations have been framed for the purpose of cooperative cane union, its internal functioning and the service conditions of their employees, which in no way is governed by the 1953 Act. Thus, there is no conflict as the 1975 regulations have been framed for a different purpose altogether. The engagement and employment of seasonal employees has to be in accordance with the crushing season, which may correlate to the actual crushing by sugar mills. This, in my opinion, is perfectly reasonable and does not suffer from any arbitrariness. It is also pragmatic as the proportionality of the seasonal engagement is directly correlated to the crushing season. Sri Alok Yadav contends that this would bring about uniformity in terms of engagement as a seasonal employee of one sugar mill with a large period of crushing season would benefit, whereas a seasonal employee of a sugar mill having a lesser period of crushing season would stand to deficit. The aforesaid argument is being advanced as if discrimination would intervene amongst the same set of seasonal employees. The aforesaid contention may appear to be attractive at first flush, but it rationally analyzed, it would indicate that a seasonal employee has to conform to the crushing season, and therefore such a disparity is inbuilt with the nature of the employment itself related to the actual supply and crushing of sugar cane. In view of this, discrimination cannot be complained of, and it is for the state government to make allocations to the respective sugar mills in order to ensure that the seasonal employees get enough work, possibly in equal proportions as per the availability of sugar cane. The amended definition, therefore, cannot be said to be ultra vires, irrational, or arbitrary. Stop.